Hi, Nell. Okay. So I think we'll get started. Welcome, everybody. We're so glad that you're with us today. We were actually hoping to share some information about the cash bail system with our BUC congregants, but it turns out that we have in our audience members of other UU churches, as you've been putting in the chat, which is lovely. And we also have members from other organizations. So if you put it in the chat, we'll have an idea of where everybody comes from, which would be really nice. So welcome again, everybody. And as members of the social justice team, we are hoping that we can help all of you learn a little bit more about the cash bail system. Just a quick intro on how we got to this point. Some of us from the social justice system at BUC is Birmingham Unitarian Church, we started to work with Michigan Liberation a couple of years ago. Michigan Liberation is a statewide network working to end the criminalization of Black families and communities of color in Michigan. It's dedicated to ending mass incarceration and transforming the criminal legal system. One of their initiatives is to end the cash bail system. The cash bail system is under scrutiny in Michigan as well as other states. Some of you may have heard about that. Cash bail touches on both economic injustice and racial injustice. Michigan Liberation partners with many organizations to address these issues, and one of them is the Detroit Justice Center. Rubina Mustafa, our presenter today, is a senior staff attorney at the Detroit Justice Center. Rubina will help us understand how the cash bail system works, how it harms people, and what needs to happen in Michigan to address these inequities. Rubina has had 29 years of legal experience and has a wide range of experiences in all matters of the law. So one more thing, we will have a Q&A at the end of Rubina's presentations. You're welcome to raise your hand, the chat hand, or you can put your questions in the chat during that time when we have the Q&A. During the presentation, however, we hope that you will give your full attention to the information that Rubina will present. Okay. All right, take it away, Rubina.
Thank you so much, Izzy, Mary Jo, and Birmingham Unitarian. I am really very honored to be here. I feel that I am today just voicing what our wonderful collaboration with Michigan Liberation and other social justice organizations such as yourself believe in and stand for. I want to help answer questions and probably clear up some confusion, and also give us a clear sense of direction moving forward. I welcome all questions and even really feedback. But I'm going to get right into the presentation. And I do a lot of Zoom presentations, but sometimes I'm a little awkward in the sharing. So I'm going to go ahead and start sharing the presentation. And I want to say, first of all, before anything, much praise to my dear friend Nell Hearns, who is with Michigan Liberation, the lead bail organizer and lead organizer and bail program administrator, for sharing such beautiful slides with me that I'm also going to share with you. So this is really truly a joint effort of our organizations, because we've worked so closely over the last 5 years together on these issues. And so, like I said, I'm just voicing what we know collectively, and what we worked so hard for, and hopefully can get much more progress in the future. Okay, let me do this correctly. I was on the wrong tab. Thank you all for your patience. Okay. So as I said, and as Izzy said, I'm with the Detroit Justice Center. We've been, ending cash bail has been at the forefront. We talk about it as bail reform, but really it's about ending cash bail. And I'll go into why that is truly such an equitable concept. But we've been partnered with Michigan Liberation on this issue, but we've been so immensely honored to work with them on the Michigan Black Mamas Bailout Initiative that will also occurs every single year. They also did a Home for the Holidays initiative, and they do wonderful work with people, not only in ensuring their freedom in this oppressive system, but really connecting with people and demonstrating that we don't need this oppressive system in our criminal punishment system. So just a shout out to my good friends there. So what is cash bail? And I put it in quotes because the word bail is another word for guarantee. So anybody who's been accused of a crime must promise or guarantee that they will come to all court dates until the case is closed. Now, that doesn't mean, that can mean a lot of things procedurally, but for the purposes of this presentation, it really means until there's a verdict or a plea or some kind of sentence from the court in a criminal matter. And a bail is a specific type of guarantee that the court imposes on a person, and cash bail is an amount of money. So the court is, all people who are accused of a crime must promise that they will come. That's the bail. But cash bail is about cash, and the court decides what that amount is. So why cash bail? Well, let's be honest, cash is king. Cash bail is easy money for the court. A person can only be released if cash bail is satisfied with cash, which means freedom equals cash to the court. Judges can consider non-money alternatives. It's in the law, it's in the court rules everywhere, but most of them don't, because it's easy to say $500 and you're out. Or, they have a captive person in the jail cell who can stay there and be at all court hearings, or just pay $500, you get to go home. But if they pay the cash bail and they don't show up for court, the court keeps the money. So it's very, very convenient for the court. This is all about convenience. And again, bail is just a promise you're going to show up to that next court date. And I don't think people, even who are incarcerated, really understand that that's really the only thing that bail is. I do want to say that, yes, there are many instances, hundreds of instances, where people are not kept based on a cash bail amount. However, our cash bail system has overpopulated the jails. And what we saw even during COVID is that there were tons of people in jail based on not being able to afford cash bail and being at risk of having COVID spread and dying. So how did we get here? Well, there's this little thing called due process, which is embodied in the Fifth Amendment of the US Constitution. And I won't read the whole paragraph, but my favorite part of the whole paragraph is what they call the due process clause, where no person can be deprived of life, liberty, or property without due process of law. And that is the United States Constitution. So that applies to everyone in the United States, including Michigan, right? So what does that mean in terms of being in custody and being in bail, having bail? I know that the Fourth Amendment, and I'm sorry, I'm a law geek, so I do like to clarify, the Fourth Amendment applies to searches and seizures and applies to arrests, and whether somebody can be arrested, and the court would issue a warrant for somebody's arrest. But the issue of being deprived of liberty, specifically when it comes to being held pre-trial, is a due process issue. And that's under the Fifth Amendment of the US Constitution. And so what does due process mean? It means that all people are presumed innocent of any criminal wrongdoing. And I'm just going to do a sound check here. Is there any problem hearing my sound at all? Okay.
I can hear you, Rubina.
Okay, thank you. Because sometimes my voice goes up and down, and I want to make sure that I'm not trailing off. Anyway, so part of that due process guarantee is all persons are presumed innocent of any criminal wrongdoing. The burden of proof is on the government, also known as the prosecution, to prove guilt beyond a reasonable doubt. You don't have to prove you are innocent. If the government accuses you of a crime, whether that's jaywalking or capital murder, they have to prove it beyond a reasonable doubt. That is their burden. Now, yes, I'm realistic. Some people will plead guilty. Some people will confess, so on and so forth. But it is never a person's burden to do that. It is always the government's burden to prove criminal legal guilt. So what does that mean in Michigan? So the Michigan Constitution also has a Fifth Amendment clause, which it also includes, which is true in the US Constitution, issues of double jeopardy, but also specifically talks about in concepts of due process, the bailable, that people are entitled to bail. In other words, they're entitled to give a promise that they will come for the court proceedings, and they cannot be denied except in certain circumstances. And now, again, I'm a law geek, so I'm going to talk about some language. We have this: bail may be denied for the following reasons. It doesn't mean it must be denied, okay? And it's before conviction, be bailable by sufficient sureties. Now, surety is a concept in the law that does occur in the criminal context, but also occurs in non-criminal cases as well. But the idea of why this was specifically put in the Michigan Constitution is to embody a due process right to pretrial release. So people who are arrested and accused of a crime are entitled to be released prior to their conviction. They are entitled to it. So it is a right you have as a Michigan citizen, or anybody who is under the jurisdiction of Michigan courts. However, as we said earlier, cash is king, and a lot of judges think, hey, I just say $500, I get $500. But the exceptions are, as you can see, very, very high. They have to be, now I said the 2X habitual offender. That means the phrase habitual offender means somebody who has been convicted of a felony, a violent felony. So if there's 2 violent felony convictions in that person's history, a court can consider that and deny any bail. They can just outright deny bail. If they are charged with murder or treason, they can deny bail. If there is some type of life offense for a violent felony, armed robbery, and first degree CSC is criminal sexual conduct, commonly known as rape. Those are considerations the court can take. They can also take into consideration things like a person who committed a violent felony when they were released in the past, whether it was on bail or while they were on parole or probation. So there are exceptions to this constitutional right, but for most people in most cases, they have this right to have bail. So where do we get confused? The concept of bail or the concept of ending cash bail gets a lot of flack from people who think, oh my God, we're not going to be safe if you allow, if you eliminate cash bail. It's not about safety. And these are two very stark examples. And I apologize, I should have done a sort of trigger warning that I was using such stark examples here, but one of the examples is there was a 16-year-old young man who was accused of stealing a backpack in New York City. His parents couldn't afford the $3,000 cash bond. He spent 3 years in custody and before his charges were dismissed. And subsequent to that, he ended his own life because of the trauma of being incarcerated for so long. Contrast that to Mr. Kyle Rittenhouse, who we know was charged with 2 murders in Wisconsin during the Black Lives Matter protest of 2020. He was bailed out for $2 million because wealthy gun rights supporters crowdfunded to raise his bail. So you have a kid who's accused of stealing a backpack, can't afford $3,000, is traumatized for 3 years in custody. Now Kyle Rittenhouse was acquitted also. I'm not going to take that away from him, but he was able to get bail and his charge was much more serious in Wisconsin. So what are these harms? So as I said, bail is a guarantee for a person to come to court, but there isn't a guarantee that cash does this any better than reminders or supportive services. And, my dear friends here on the call that are from Michigan Liberation will tell you, they have the proof. They can show you the receipts that if you help somebody get to court, if you remind them, if you support them, if you are behind them and they know they're not alone, they will go to court and take care of their matters. Cash bail actually, when it became a cash cow for courts, actually increased jail, the inmate population, and not only adult populations, but also juvenile populations. So it increases jail populations, which increases the services that are needed and so on and so forth. It's, of course, disproportionately hurts the poor because a person who cannot afford a couple of $100s for bail is going to stay there pre-trial. They're going to lose their job. They may lose their housing. They may lose their children. So that's breaking up families, increasing homelessness. But there are statistics that this harms people even after their cases are closed. And I actually, the uncash bail policy of the Washtenaw County Prosecutor's Office actually cites some of that data in their public statement about ending cash bail. There is, I believe, either Internal Revenue Service data or other data that supports that people who have not been able to afford bail, not just anecdotally, but overall, the trajectory of them ever getting back on their feet, just because of not being able to afford bail, is damaged for many years after their case is closed. So there has been, and I am going to pause here. Izzy, Mary Jo, is there something I missed or should address further? Okay. And I certainly will take all questions as we go on. I kind of want to get into the meat of what we need to change here. So what is ending cash bail? And I'll be honest, before I go into the legislation, I probably should talk about why I'm saying ending cash bail besides bail reform. Truthfully, I'm a constitutional rights person. So if you have a right to be presumed innocent before, and it's the government's job to prove that you're guilty of any kind of crime, and they have to have the evidence, they have to have the receipts, then my position is you should be free. Freedom should be free. There should be no imposition where you have to buy your freedom when the government has the burden of proving that you've done anything wrong. They have to prove you know, that safety is an issue. They have to prove those things. And so in other systems, I did mention Washtenaw County, the federal system. Now, technically, there are cash bonds that people do when they are arrested for federal crimes. And yes, those are far more serious, but for the most part, judges do a specific custody hearing. They do a release hearing. They go over a lot of factors about whether someone can be on release, maybe supervised release, maybe not supervised release, but they do have a hearing. So ending cash bail is really about making the system fair for everybody. So when we have to balance the questions of safety and the questions of justice, you can do that, and it has been done in the federal system for many years. We could even say that the federal system needs improvement itself because it hasn't, you know, completely eliminated it. Because we know that the poor are disproportionately prosecuted versus in comparison when we compare people who are economically stable versus those who are not. But it does exist in the federal system. In Washtenaw County, it's a couple years old. They have found that there is more compliance and the cash bail isn't necessary, and they've kept their policy. Now, that's the prosecutor's office. There are local municipalities may still use cash bail in the Washtenaw County system, but that's on the county basis. And I don't mean to confuse, but there's different jurisdictions that can implement the policy differently. And Illinois passed the Safety Act. And I was trying to look to see if there were statistics, but it's hard because Chicago has a high crime rate. But so I don't know how the statistics are being compiled. And the Safety Act, it's SAFE -T Act, was passed in Illinois, and it was challenged. And the litigation ended pretty much by the Illinois Supreme Court upholding the constitutionality and the validity of the legislation. So it kind of officially went into effect September of 2023. So it's a little early to say what the data will show in Illinois, but part of what was successful in Illinois is the individuals who were on the ground like we are fighting for the end of cash bail really brought the receipts and really brought the facts that this bail question isn't about safety. This bail question is only about guaranteeing to appear for court. It doesn't take away any powers that the courts or the prosecution or the police have to hold people accountable for their behavior. Cash bail is only about cash. So having said all of that, I'm going to transition to another PowerPoint. So please be patient while I get to that point. Okay, can we see that okay? Okay.
Yes.
So the cash bail bill package that was introduced in 2023 actually never got a committee hearing, which is sad. I believe that this is, and Nell, correct me if I'm wrong, the 5th time these bills have been introduced in some form or fashion. There are a lot of things it addresses. So I told you what bail was and what it wasn't. There are different circumstances. Uh, Here, let me. There are different circumstances that it addresses. It's not eliminating cash bail, but it has to be reintroduced because the session for that they were introduced in went and passed, so it would have to be reintroduced again. I believe, yeah, because it was introduced in May of this past year, so the package would have to be reintroduced again. But there are a lot of positives in terms of restricting the use of cash bail and using other release conditions. Again, it's not abolishing bail outright. And if they get reintroduced and there are some changes to that, there are some changes we would like to see, but we may see things that are not things that we like. But I'll go into a little bit more, and I have to give credit to Erin Keith, who is our managing policy counsel at Detroit Justice Center, who speaks on this all the time, and I'm sure she would love to be here, but she's on sabbatical, so we're going to respect her leave time, and I'm pitching for her here today. But one of the limitations, this serious limitations, again, we were talking about safety, the court shall have hearings. So how I was saying in the federal system, they actually have release hearings. That would be required in Michigan. They would require hearings where the court has to make a determination if they are going to keep somebody in custody with a cash bail requirement, that there are these risks. And that includes a risk of non-appearance, like they never show up to anything, or that they would, or absconding, which is taking off, that they will be a harm to another person, like in cases of domestic violence or into the community. There are definitions of personal harm or the community at large, which can be problematic if they're not given a proper consideration, but they are considering at least having the release hearing consider these factors. They do consider the violent, whether it's a violent or assaultive offense, whether it's a serious misdemeanor, whether, what the charges were, but they must also consider, let me see. They must also consider a person's ability to pay. So again, when we're talking about cash bail, it's about cash being king and people being forced to pay for their freedom. Many of the people who have been harmed by cash bail simply cannot afford that. So the goal of ending cash bail would not require cash for that. But if the court is going to require any financial obligation on the part of the accused, then they must do so with considering a person's ability to pay. Under the current law, and so I know there may be questions on this because I don't want to confuse, but under the current law, there are some limitations in terms of, well, if the fine is, a certain amount, the bond can't be more than double that amount. Or if the sanction is such and such, it can't be, it does talk in terms of numbers. But if a person cannot afford a fine, they're not going to afford double that fine either as a bond. So what's nice about at least this consideration about the ability to pay is it's not dependent on what the punishment will be. It's not punishing the person beforehand. So they must consider an ability to pay. And if there is no ability to pay, they can consider what they call a non-monetary condition. And I will go over that in a little bit, but I wanted to sort of highlight that. And here are examples of non-serious and non-violent crimes that can be charged of people. And again, nobody's saying there shouldn't be consequences for behavior that violates the law. This is just about legitimate fairness. If a person is accused, they have the right, as we know, under the Constitution, under due process, to be free pre-trial before they are convicted. They should not be punished before conviction. And so there's some recognition here that, okay, if safety has to be balanced, there are certain cases, there are certain examples of offenses where, yeah, we know, like for example, retail fraud is not necessarily is not a danger. I mean, it's, they probably have to stay out of Myers or Macy's or some other store, but they're not a huge danger to the public. They can stay out on what they call personal recognizance or not having a money condition for bail. And so what are other positive features? We have a guarantee of a speedy trial with a time limit. So, as I said, one of the sad examples that we've heard is people spending years in prison. And if they're going to have to be in custody, there is a time limit that they can have the case dismissed if it's after 18 months. They will be more clear about what non-appearance is before, rather than absconding. And those are legal terms, but non-appearance actually was an issue in the 2020 reforms. And we did try, I know we all have talked about it. We did try to get that reform legislation to basically say no warrants would be issued. But the most they would give us was that warrants would be used much more sparingly. So for non-appearance, the assumption would be the person didn't get the notice, they didn't have a chance, they would call the court, they wouldn't have, so for non-appearance, you missed your court date, basically, they would not issue a warrant. Whereas absconding is a different definition. It's a definition of you knew you had to be there. Like the judge said, come back tomorrow. You said, okay, judge, I'll come back tomorrow. And you willfully decided you weren't going to show up. So there's a legal difference between that. And it's important to point that out because the law allows the judges now to issue warrants for non-appearance, not as easily as they could before 2020, before the 2020 laws, but non-appearance and absconding aren't per se defined in terms of not showing up for court. And this would at least clarify that. And there were some other issues in terms of electronic monitoring that hopefully would be tweaked out. I can't say what would happen when this is reintroduced, but our position, as abolitionists, is there shouldn't be electronic monitoring. If you're free, you should be free. People are often put on tethers, either an electronic tether that they have to be at certain places at a certain time, a GPS tether. Sometimes it's, a drug testing tether. And it's just another form of incarceration. So we're against all kinds of pretrial monitoring. However, some of that is in this legislation of circumstances when that would be allowed. Pretrial Services Division would be created under this new legislation, which creates a division within the county court system or incarceration system administration to monitor and provide data. So it would not only provide data as to who is on pretrial release, but the idea is it would also provide data on things that people needed. So potentially, I mean, the goal is to service people to make sure they get to court, even if it's giving them a ride or a bus ticket or a reminder. something to ensure their appearance. Again, it's supporting their coming to court. It's not punishing them because they have court. And of course, the big one, the ability to pay. Again, because the laws now allow for judges to have wide discretion in setting amounts, like I said, double the fine. The ability to pay assessment is incredibly important. So having data, I mean, we do, from the data we do have, we do know that people of economic, who are in lower economic status and disproportionately people of color are affected, but this would definitely create a government-based data system that quantifies exactly what's happening, who's impacted, and the effectiveness of pretrial services. So, you know, I probably don't want to spend too much time on this. I did reference the release hearing, but the reason I wanted to talk about this just a little bit is this is talking about a conditions review hearing. So, and this is getting a little more into procedural issues, but it's important too, because this would come into effect if this law ever passed. It would come into effect in two ways. So the first way it would come into effect, and this is what's happening in Illinois right now, is that people, because there's no cash bail now, the courts are supposed to have a review of people in custody to determine their conditions, to determine whether they're eligible for pretrial release, and consider certain factors. This is this language that you're looking at on the screen is from the Michigan bills, and it gives some idea of what would happen in this situation where Michigan passed an cash bail statute. But the other piece of this is looking forward, going forward, that if there was an encash bail statute and a person was denied bail or did not have the ability to post the cash bail that was set for them, there would be at least the opportunity after 60 days for them to have a review hearing before the judge to determine whether they were entitled to pretrial release, if they were a risk, and so on and so forth. So it has two functions, and I know that's getting really into the weeds of like, you know, court procedure, but it is an important component because some of the harm we've seen of people having to stay for very long periods of time is there's very rarely an opportunity for them to challenge their pretrial incarceration. So I know I was kind of referencing this as I was talking, but the definitions of, you know, personal harm to the community at large, you know, it may not restrict those situations. So for example, and the one thing that comes to my mind is people who might have mental or cognitive disabilities. You know, oftentimes they are disproportionately arrested and you know, categorized as dangers when they actually need resources and help. So, you know, rather than giving them harm, are they going to stay in custody because that's safer for them or others? And in terms of juvenile adjudications, as we were talking about, they use past history. How are they going to use that? And it's not always clear in legislation how that happens. The spree trial length, again, freedom should be free. Why are we talking 18 months? So that can be really long. And in terms of, you know, sort of, you know, the factors that they're using, so I know there's been proposals of using risk assessments and, you know, the person's criminal history or whatnot. That isn't always the best tool to do that. And there are people who are sometimes convicted of violent offenses when they weren't the key person. They may have been a co-defendant. They may have been involuntarily charged. They may have pleaded because they had to spend jail too long. So yeah, I'll plead to armed robbery if it means I'll get out sooner. So those are also imperfect tools. And bottom line, of course, abolitionist, it's not abolitionist. Again, we're starting from the Constitution, due process, you're free, and you have to be proven guilty before you are in custody in jail as a punishment for your crimes. So that's the big thing we don't like, but we know it's a work in progress. Anyway, let me see, do a time check here. So I'm gonna go back to this presentation. Thank you for your patience while I'm navigating Zoom. It's very much appreciated. Okay. Hit the wrong one. Let me try again. Where that is. This is where this is. Okay. So we did talk about how the proposed bills limit cash bail. You know, the court has to have a determination on the record. This very important thing. They have to determine that that individual, not just Joe Blow, your bond is $500. That individual presents a clear and convincing risk of not coming to court, absconding, which means willfully not showing up for court, or presents personal harm. You know, again, non-appearance is missing court. Absconding is willfully not showing up for court. And personal harm, and I really appreciate Nell putting this together, like it's bodily injury or emotional distress. Again, this may not be very inclusive because we're talking about people who may have mental health issues or cognitive disabilities. So will there be some assessment about this that is supportive of the person and compassionate? This is kind of a gray area, we're not sure. But again, there has to be clear and convincing findings and evidence that the prosecution must present to the court that this is what is the case in order for the court to make a finding that this person is at risk unless they are in custody and determining their bail. And that drug use by itself is not considered a community harm. It's an improvement, again, in considering a compassionate response to people's needs. So we have a little bit better definitions of these things. And, you know, if there is no risk, then they get to be released. Their freedom is free. They can be released on personal recognizance, which means no cash is required for bail. There are conditions for pretrial release, but cash is not one of those conditions. And they must use the least restrictive non-money conditions. I did refer to electronic monitoring before. There are a lot of courts that require payment for electronic monitoring, which is essentially you're putting them back in the same position as cash bail. So they could have no bond, and we've seen those cases where people have no bond, but they have to pay for their monitoring. And since if they can't afford it, it's the same thing as cash bail. So this at least is saying, you know, non-monetary conditions of release. You know, as I said before, they have to have these factors. They have to do findings of fact in a open court hearing where they are finding that this person is an actual harm and what facts make that the case. And again, that's the prosecution's burden. It's not the individual's burden. So there are always in pretrial release conditions. And I'm sorry, I could talk about this for hours, so I don't want to get too much into the weeds, but this is true. When now, if a person gets cash bail and they get bailed out and they abscond or they commit a new offense or anything, that bail can be considered broken or revoked, because they did not meet the conditions of their pretrial release, which is usually they must show up to court, and they must not commit new offenses while out on pretrial release. So generally speaking, this is, consistent with law that there is now. So again, we were talking about ability to pay. This would make a huge difference. There is consideration of a person's ability to pay. I believe there is going to be forms that would be given out to people to actually fill out their assets and their actual abilities and finances, so that the court it's not in the court's ballpark as to how much the cash is. They have to give reasonable, achievable ways of pretrial release if they believe cash bail is required. Now, EM is, of course, referring to electronic monitoring, which, as I said, we oppose. But if electronic monitoring is required, and it's not available, then the court must consider that they can be released without electronic monitoring for other conditions, or they just can't hold them indefinitely until electronic monitoring is available. And actually, during the pandemic, we discovered that there were people who were given no bond, and they were kind of deferring some electronic monitoring payments, but there was just not enough people to do tether during the pandemic to get people released. So people were waiting for days to get electronic monitoring. So this is something that we've seen can be an issue, and people shouldn't have to be tied to a system that isn't that isn't prepared to deal with it. So we shouldn't punish the person who is innocent until proven guilty with a system that isn't prepared to deal with. So, and as I mentioned, the financial disclosure form would be provided to each person to list their assets and abilities. And as we know, getting people out of custody reduces the jail population. I think, this, points out the positives we've already said. Having data collection at every point, 60-day automatic conditions review hearing, letting people know that they have a right to have their conditions reviewed if it impairs their liberty. This is true for people in custody, but also going forward if the bill passes. And having a pretrial services division, and again, the goal is to have a division that supports people coming to court rather than punishes them for having a court case in the first place. So I'm going to stop here, because I could go on and on. But and I love the last question that was posed about what makes our community safer. But I do want to invite people to think about that question, but also, to join us. You're welcome to join this movement. And, the pledge we're taking is bold against bail. And I will read it because it's a beautiful statement. So give me a moment to share that part of the screen. And I will also share the link, but I want to first share. And like I said, our wonderful collaborators with Michigan Liberation and all the wonderful people who volunteer their time, including some people on this call, have brought this. Now, how do I expand this? Oh, something is up here. Here we go. Okay. As Michiganders, we value liberty, equality, and community safety for everyone. These core principles should serve as the foundation of our state's criminal legal system. Yet our current cash bail system undermines these values by jailing people based on the amount of money in their wallets, thereby driving racial and class disparities with no improvement to public safety. One day in jail pretrial can mean the loss of homes, jobs, and even children, while a person is still legally innocent. We know that we can achieve true public safety by investing in housing, education, mental health, and employment. What is the pledge? I will join with others to call attention to the harms of the cash bail system and demand a change in laws and practices, eliminating cash bail use throughout Michigan. I pledge to be bold against bail, knowing that contributing my power can change everything. So kudos to my colleagues for coming up with that beautiful statement. And I'm going to copy the link and share it in the chat. Oh, I should have kept that up. I'm sorry, but I'll do it later. But I'm sharing the link in the chat for those who would like to sign up for Bold Against Bail. And thank you for being such a lovely audience. I do see some good questions in the chat, but I'm going to let my hosts guide me where I should go next.
So if you have a question, please raise your hand. Otherwise, we'll go to the chat and see if there's any questions over there. So I'm not seeing any hands right now. So the first question, Rubina, is from Randy Block, and he says, what about middle income people who can afford bail? Is there a criteria for who must pay bail?
Randy, thank you very much for that question. So the concept of bail is, again, that guarantee that you'll come to court. So anyone who is required to have a cash amount when they are in custody must pay bail. So currently under the system, it's discretionary for the court to say, oh, if you're poor, I won't make you pay bail, or there's something else I can do. It's up to the judge. And since there is no income screening or ability to pay assessments done, a person who can afford bail is simply affording bail and they're getting out. So there is no, actual income screening. Now, they can certainly, I've seen bail hearings, or not bail hearings, but custody hearings where a person is arraigned. They're arraigned after being in custody, like they're arrested, they got picked up for a suspicion of a charge or on a warrant or what have you. And they'll say, oh, I'll lose my job, I do all this. Those are things the court can consider, but they usually just set an amount and they don't ask, there is no actual assessment of income. So, the question is should there be a cash requirement? And we say no. I mean, whether you're a millionaire or you're, on food stamps, there shouldn't be a cash requirement for your freedom because you shouldn't be incarcerated. And I hope that answers your question, but feel free to ask another. Do you want me to go to the next question, Izzy?
Yeah, please. Oh, I think, does Randy have his hand up? Randy, do you know? Okay.
No, I got the question answered.
Okay, good. Yes, the next question is from Mary Masson, and she wants to know who has cash bail jurisdiction, the local, county, state, federal? Is the reason people sit in jail when they do not have cash bail for any period they do not have, sit in jail for any period is because they had no hearings. Is there a time limit from being charged to a hearing?
I love you, Mary. You're a deep thinker just like me. You have so many questions. I will answer each of those. So who has cash bail jurisdiction, local, county, state, or federal? So the wonderful thing about having many governments that we answer to is that each of those governments has jurisdiction. And if they have a criminal enforcement system, then that particular system. So for example, if it is a city offense where it's under the city code, then the city court and the city judge would have jurisdiction. If it's a county case, which most felonies are, so just, I'm sorry, I like the geeky stuff, but under most laws in the country, including Michigan, felonies are usually things that are punishable by more than a year of incarceration. And most of those would be prosecuted at a county level or something similar to a county. Now, county prosecutors can prosecute people for lesser serious offenses, misdemeanors, and so on and so forth. But for the most part, their jurisdiction is felonies. And in Michigan, the felonies are prosecuted in the circuit court, but they do start in the district court. And I'm sorry, I'm going into procedure. But if a person does violate city ordinances and they're being prosecuted in the local court or the city court, it's that court that has jurisdiction. Where it gets confusing for people is, let's say in Detroit, a Detroit Police Department person arrests somebody for a felony. Yes, they're a city officer, but they are arresting them for what is a state felony. So it's the charge, the seriousness of the charge that determines the court, not the arresting agency. So it could be an arresting agency that is the city, but it's because the charge ends up being a state case, it ends up going to the county prosecutor. In federal, similarly, federal crimes are prosecuted by the U.S. Department of Justice and the U.S. Attorney's Office. It doesn't mean that it's somebody, very rarely do you see a lot of people being prosecuted both in the state and the federal system, but I've had clients prosecuted in both the state and the federal system. So they do have independent jurisdictions. Is the reason people sit in jail when they do not have cash bail for any period is because they had no hearings? Actually, no. Generally speaking, there is a timetable that courts are supposed to follow. So generally speaking, for most jurisdictions, there is that first hearing, which is called the arraignment. It can also be a release hearing if a person wants to discuss release, but it isn't mandatory to talk about release. I mean, generally, when I've represented clients, it's been like, Your Honor, my client's in custody, can she or he be released on bond? The court, again, it's up to the court whether they want to consider other factors, consider non-cash items. It's very discretionary. There's nothing mandatory at this point for them to consider things besides cash. They're allowed to, and they can, but they don't always do it. But most often they don't. So they do have hearings because they have to, after being arraigned, then they have pre-trials where they might discuss evidence, they might discuss a motion schedule. So there's a lot of different parts of the procedure before a trial or a plea is entered. So there are hearings, and you can bring up custody issues at any hearing, but again, there's no mandatory procedure now for the courts to consider conditions of pretrial release or pretrial custody under the current system. It's discretionary with the court. And is there a time limit from being charged to a hearing? So the current, in the under the United States Constitution, there's in the Sixth Amendment, the right to a speedy trial. It's never been actually defined what a speedy trial is. So it's been defined by each jurisdiction based on case law. In Michigan, there is a 6-month statute for the speedy trial. You could talk about a violation of speedy trial. But generally speaking, a constitutional violation of a speedy trial can be very difficult to achieve, because there are so many, like I said, pre-trial hearings that go along. And the case law generally says that, you know, like if a defendant files a motion, oftentimes I would file motions for my clients to suppress their confession or to suppress evidence that I felt was in violation of the Fourth Amendment, you know, and they could say, well, you know, you didn't have your trial in 6 months because you filed a motion, attorney must have filed, so you can't claim about speedy trial. So it's not always an easy thing achievable. But there is the guarantee to a speedy trial. The constitutional amendment that I was showing, or the Michigan Constitution, Section 15, does talk about if bail is denied, then trial must commence within 90 days of the denial of bail. I'm sure, you know, there's been exceptions to that as well.
Sorry.
No, go ahead.
One of the reasons I asked that question is, you know, I'm a victim of getting most of my information through radio, mostly PBS, television, newspaper, print. So you're not always sure about how the validity is of what you're reading. But in our Metro Detroit area, I've read several articles in the last year about where a person did an auto violation, like they had an expired driver's license, so they didn't have their sticker on their license plate. They were put in jail and sat there for months because they didn't have any bail money, and they lost their job, they lost their home, they had to find child custody care. So when I don't know if I'm using the right term, I'm going to say smaller crimes, nonviolent crimes, or whatever, they're treated the same as if I'd done something more heinous. And am I getting the story wrong when I say this? Was this a sound bites that I've read that are erroneous, or could there
No,
be truth to them?
you're correct. I mean, so for example, that does occur. So what I can say is, for example, if someone, and I do a lot of traffic work, so I would say for the vast majority of my clients in the traffic court, they are not finding themselves arrested right at the traffic misdemeanor, right? For having, you know, not having a valid license or a suspended license. Prior to the reforms, before October 1st, 2021 and April 1st, 2021, police officers had a lot of discretion. So you had a spectrum of what things could happen. So what you've seen, yes, has happened. People have been arrested. I've had clients who've been arrested multiple times for having a suspended license. And their reasons for having a suspended license was they couldn't afford the first ticket they got. So for decades, they were not able to restore their driving privileges and racked up the tickets. So because they had so many suspended licenses, they were, you know, arrested over and over again. The reform specifically that came out of the 2020 reform legislation was for these non-serious misdemeanors, for non-violent crimes where they're not posing, again, unfortunately, puts that discretion in the police officer's court, but it did at least discourage arrests in those situations. So it's like the message is getting across. How effective it is, it's hard to say because we've only got a couple of years of data, but the idea was just don't take people into custody because you can't, you know. And I can go into a whole bunch of Fourth Amendment stuff too, but that did occur. However, the reason it occurred is the reason you said, and this is why I love that you're such a deep thinker, Mary, is because they could, right? Again, cash is king, you know, because you can arrest somebody for a misdemeanor because the Constitution allows, if you have probable cause, that you can take somebody into custody and then require a cash bail on their release. Because they can, they do, and it happens quite often. And these are serious. And so what we're saying is that doesn't make sense in a world where you're also saying a person is entitled to be presumed innocent, and entitled to be free. So why are they doing it? Because of the cash. And I saw some other hands and I don't want to,
Thank you.
because I could talk to you guys all night. You're great.
Yeah, I have several questions, Izzy, if there aren't any others that you're seeing.
Yep, go ahead.
So Rabina, I have several questions. First of all, a question for clarification. My understanding of a lot of what you were showing us tonight, like you were highlighting areas of legislation, for example, and some of the slides that came after that. My understanding is that that's what's been proposed. And
Correct.
it's not what we ultimately want. Ultimately, we just want no cash bail at all. But the legislation that's been proposed would be better than nothing, would be better than no change at all. Is that right?
Yeah, yes. So, I mean, we have an abolitionist stance because, you know, ending cash bail is really the goal. There should be no cash bail. If, you know, I try to keep it simple. You're innocent until proven guilty. It's the government's job to prove that you did something. So if you're innocent, you should be free. You shouldn't be incarcerated and in custody and in government custody because you've been charged, because you are being punished, you know, and that also goes to the trial release conditions, like shouldn't have to pay for electronic monitoring. You shouldn't have to pay for drug testing. I mean, I've had people had to pay for drug testing for driving while license suspended, which has nothing to do with drug use. You know, and I'm sure all of you have known somebody impacted by it, you know. So the problem is that the system sort of reinforces itself. And, you know, and so if we end it, that takes away any of the discretion, right? They can't be like, well, this in this case, and what are you going to do about this? And what are you going to do about that? Right. Without understanding the basic, like, my religion is that you have freedom until you are proven guilty of something. So having said that, as strongly as I do and feel, this legislation would go a long way in recognizing some really important things. One being that pretrial freedom is a constitutional right. You know, it is saying bail is a right to everyone and that it is an individual decision that has to be made to keep somebody in custody. There's something called like the economies of justice. That's a concept that gets thrown around a lot in appellate case law. And usually they're in state cases, and it's because they don't want to make the judges work too hard. It's the economies of justice. And so, you know, a sneaky way to get around that is to make their job harder. You know, if they had to arraign every single person and consider individual things for every single person in terms of custody and have to write, you know, an opinion or have to be appealed or do all this stuff, maybe they'd let more people out on recognizance. But, you know, that's my little conspiracy idea myself. But having said that, truthfully, it is what is required. It is what is required that people get due process. No, it says it right in the Fifth Amendment. No person shall be deprived. No person, not one person, shall be deprived of liberty without due process of law. So everyone is entitled to this, right? So that's how we're getting our foot in the door, is saying you are violating our basic constitutional rights to an individual determination of our risk to safety. Are there situations, like for example, and again, I'm going to do a trigger warning because I know there's some violent people out there, right? So like a school shooting, right? And Ethan Tremblay was just convicted and sentenced to life without parole. You know, there was a lot of debate about whether he should have pretrial release. He was denied pretrial release, but because due to the charges. You know, am I going to be insensitive and say the people who wanted him to stay in custody were wrong because I constitutionally believed he is entitled to pretrial release? I still stand by my principles, but I understand there's a point for debate, you know? So it takes time to really point these things out. And I think more than a lot of the naysayers will point to examples that are extreme rather than examples of the vast majority of people that are harmed by this. There are many, many more people who lose their jobs, lose their housing, you know, and are financially unstable for years due to not being able to afford cash bail. And the Illinois efforts show that. I mean, we have the data too, but really that's what took it over the top for Illinois. And it really, when you look at how the system is implemented, you see that something has to give. So one of the things that like, and I'm going to give Erin Keith, our managing policy counsel, credit for this because she's looked at this very closely, as well as Safe and Just Michigan, which is also our organization that works with us, John Cooper. The issue is political, right? I mean, at the end of the day, we have to have a consensus as a state about what we're going to do about this. Can we bring more people into the bold and against bail fold? Absolutely. And we need to do that for the vast majority of people who are harmed by this. You know, not the extreme cases, not the exceptions, but the vast majority of people who are harmed by cash bail. We can do that. But we have to contend with the fact that there are going to be extreme cases, and we have to give, if we want clear direction, we have to give courts the tools to use them. So as hesitant as I am about being a reformist, I understand the realities. You know, we're all practical people here. But reform does go in the right direction. We have seen that with the 2020 legislation that was passed. It leads to better conversations. It's leading to some cleanup legislation for some other matters. So we're making progress. It may be challenging to have these conversations. And one of the things that I wanted to be able to provide is people kind of with a script of like, what do you say to a policymaker or a county official or a legislator about why you're bold against bail? You know, for me, it's like, don't punish poverty. Punish behavior, punish crime, don't punish poverty. Or it is, we have more to gain by stabilizing the community and making sure people are in their community, taking care of themselves and taking care of their family and supporting them in addressing their court cases. We have more to gain as a community than we are losing in how the system is now. Because if you destabilize a family, you create poverty, you create homelessness. Let's stabilize people. You know, as Mary said, I mean, if somebody's in jail for driving with suspended license, how does that help anybody? It doesn't. So let's support them getting to court and resolving their case. There's other ways to give people consequences or pretrial release conditions or ensure that they get to court. Bail is just about getting to court. And there's 5-cent solutions for that problem. And they're spending way more than that to create even more problems in our community. I'm sorry, I go on and on about this, but please, any more questions?
I have a couple other questions if no one else. I want to make sure others get a chance.
I don't see any hands up. Go ahead, Mary Jo.
Yeah, so Rubina, my next question is related to what you talked about here toward the end of that answer, and that is, what exactly can we do? Many of us who are here tonight represent larger organizations, and we are the conveyors of information to larger audiences. Um, who is actually, like, how is this organized in the state of Michigan to get that legislation reintroduced and to get it to be as close to ending cash bail as we can get it, while taking into consideration some of the circumstances that you did mention? Are Detroit Justice Center and Michigan Liberation in the lead on that, or part of in the lead on that? Like, who is structurally, how is this working?
Well, so on the ground, the grassroots, I'm gonna put Michigan Liberation on top, because the rock stars that are on this call with us, Ms. Nelson, are, I love my Michigan Liberation newsletter and communication, and all their social media really keeps me informed, lets me know what to do next. Safe and Just Michigan is another organization. Definitely our organization, Detroit Justice Center, but you will get a call to action from any one of the organizations, because we are in coalition with each other. We're side by side in this fight. There's also the ACLU of Michigan. Now, the ACLU of Michigan did have, has done some great work in terms of the settlement they had with 36th District Court, which actually eliminated, for like traffic cases, they eliminated the bond requirement. For new cases, unfortunately, they exist for old cases, but they eliminated the bond requirement for these traffic cases. There's great leadership, and we are all talking to each other, and we're all working together in coalition. So any one of those organizations, you could go to Michigan Liberation's website, Detroit Justice Center, and sign up for our newsletters to find out. But there is where I have really, again, such respect for Michigan Liberation, is that they've actually had the Michigan Mothers Day bailout, as well as the Home for the Holidays programs, and we've been able to refer clients and refer other people to them to actually get relief and put this data together of how supportive services are. So, and of course, wherever you are, I'm happy to, talk to your members and your networks. But the important thing is that we talk about it, and we are, the concept of being bold against bail is really being bold for the community. And, I have been in front of less friendly audiences. You guys are wonderful. But generally speaking, the concept is what I hear from naysayers mostly is, what about the victims? What about what's going to happen to the victims if we don't, protect them? And we care about safety. As we said in the pledge, we care about community safety. That is very much a huge part of this principle. But you ensure community safety by ensuring community stability and really addressing questions of safety. Putting somebody in jail because they didn't show up for court for a traffic case is not about safety. It's about cash. So if you want to talk about safety, yes, let's have a conversation all day long about safety. But this is about ending cash being the king. It shouldn't be the determination of freedom. Our freedom is guaranteed to us in the Constitution. It shouldn't be paid for. by the people who can least afford it.
And then one other quick question, if I may. This is in a little
Sure.
different vein. Some of our legislators may not be very persuadable on the basis of the injustice of this, or, you know, your argument about the stability, the importance of that stability to security ultimately. However, this is very costly, right? I remember hearing, it's probably a while ago now, it costs at least $100 a day to hold someone in jail because they can't pay bail, and that money doesn't come back. So is there an argument, a piece of this argument to be made that this is awfully costly for our state, maybe for our county, or are the numbers not big enough for that to matter?
No, they do matter. And I think so there's a couple of pieces of data that are really important. So the Vera Institute in as part of the work of the pretrial and jail task force that took place, they released their report in 2020 along with the commission, the task force releasing their report, and it has a good amount of findings that really probably, and now correct me if I'm wrong, I think it's like 3/4 of the people in jail are pretrial and for non-violent offenses. So they definitely came with the numbers, and it was Vera Institute, which is a national organization that went, I believe, to some of the larger jails and was able to compile that data. So it's definitely in the task force report. It's definitely in the Vera Institute report. But there's also, I believe the Marshall Project, Safe and Just Michigan, also have data in their on their websites as well. You know, just for national, people are interested in Safe and Just Michigan has state statistics. Marshall Project is a national organization, but you know, there's the economic piece, but there's also this is reminding me, thank you so much, Mary Jo. Americans for Prosperity is actually considered a conservative leaning organization, and they are very supportive of ending cash bail. So, you know, for sometimes when, you know, you're looking at alternative arguments, you know, it might be helpful to refer people to organizations that they may respect more than the ACLU or Detroit Justice Center. I don't know why, but Americans for Prosperity is conservative leaning, and they very much support ending cash bail. And there are quite a few conservative leading organizations that do also support ending any court-based debt as a use of the criminal legal system, because it does have such a negative impact on the community at large, to the economy at large. One of the other projects that I do and spend a lot of time on is the Road to Restoration Clinics, which is a project with the Secretary of State's office and private law firms like Miller Canfield, but also DTE Energy. And the reason DTE Energy got involved, as well as other employers are coming on the bandwagon, is employers are having an incredibly hard time keeping and hiring people because they're just thrown in jail all the time for, you know, these minor offenses. So incarceration for somebody who needs an economic argument affects the economy. It affects just the running of the economy because you don't have people out there to work. So yeah, it's, you know, this is really bipartisan in many ways. I think, you know, our political landscape is complicated, but there is so many similarities in terms of what people agree on. People agree on people being self-sufficient. They agree on them being accountable. But they also agree on things being fair. And a person's ability to address their court matter shouldn't depend on their economic status. You know, and if the conversation is about safety, it should be about safety, not about what's in their wallet. So But hopefully, what we're looking at now, one of the things that was great in 2020 is we did have this bipartisan reform effort. They didn't quite, the bail package was introduced then, but it didn't quite make it there. It never got to a committee hearing for some reason in May of 2023. I mean, the session was ending fairly soon. You know, and I'm not saying that there aren't, you know, I mean, there are people in both political parties that support this, because there is bipartisan support for it. It's just that right now we're going into an election year. Well, we're in an election year, which is very politically charged for so many other issues. And, you know, we know that the winds of politics tend to be very sharp in an election year. So the question is, how do we let our legislators know and policymakers know this is important? And I've found that over time, when they hear from their constituency and they hear from people in the community, that this is important and this needs to be addressed, it will be addressed. So for example, recently in the juvenile justice space, they were able to eliminate a lot of fines and fees, because this was something that was impacting many, many people all over the state, in terms of having this incredible court-based debt for cases in the juvenile court. And it just seemed that didn't serve any purpose. That's not the purpose of the juvenile court, to raise funds for the court. So why were these being imposed? But it took lots of conversations, lots of organizing, lots of pressure from the public to their elected officials to say, hey, there's too much going on here, like, stop. So grassroots organizing, what you guys do and what you talk about, is really meaningful. And it's, you know, I tend to hear what people have to say, and I'm willing to work towards a consensus, but justice has to be the outcome, right? And so how do we get to justice? There's some people we're never going to convince. There's a lot of judges I haven't been able to convince about getting people pretrial release. And like, for example, I had during COVID, I had a client who did get COVID, and I asked for pretrial release, and the judge was like, how bad is he? Is he dead? Does he have to go to the hospital? You know, and I believe he had already been sentenced. But he was close to, you know, he was, you know, close to getting out of jail anyway. So I was just like, he's sick, let him go home and get better. And he's like, well, is he dying? You know, so it's like, okay. So, you know, there are some people you're not going to convince, you know, but I think it's about really letting people know that the information is out there if they want to be informed and educated, and that this isn't about us versus them. This is all of us working together for a better, safer, more stable community. You know, we are doing this collectively to make it better for everybody. So this isn't a us versus the police, us versus whatever. It ultimately makes the court's job easier if they know people are going to show up for court, and they don't have to issue warrants, and they don't have to do bond hearings, and they don't have to do this. We can make the case that your life would be easier if you just made it easier for people to come to court. So yeah.
Yeah, one more final question here. Izzy, are you seeing the question here about how to get to the pledge?
Yes.
Oh.
But I was going to see if that question we just need to put it on our whatever visual we have. But if nobody has any questions, we do need to come to a close. And the question, Rubina, was to see if you could put the bold on
Bold against
bail. Yeah, the link that they can sign it. If you could put
Yes,
it in
and I will
the.
definitely share it with you as well. Thank you again, Ms. Snell.
Put it in the chat.
Yeah, there it is again. No problem.
Okay, I think she couldn't open it, so she wanted you to see if you could put it on the,
Oh, on the screen. Okay, sure.
yeah, on the screen, because she couldn't see it.
Yeah, and we
so-
can also, if it would be helpful to people in our audience today, we could send that out through email to you
Yeah,
as a follow-up
That's
to this tonight.
that's a good
Regarding
idea.
that link, I would advise people that it is an H letter O, not a zero. That was my trouble initially.
Oh, okay,
Once I found Michigan Liberation, and I on that did not get to it either. Thank you very much.
No problem.
okay.
But this doesn't have the pledge that I think you put up.
No, this is so when you click the link, this is what it will lead you to. Is the Bold Against Bail pledge
All right.
itself.
Thank you very much.
And then it automatically, so this is a Google form. And so it will automatically identify, like, this is my email address. So it automatically identifies this address. And then you put in your email, and then you hit next. I've already done it, so I don't know if they'll let me do it again. You know, just put in your information and how did you hear about us. And I think it's a pretty simple form. My recollection was it took like less than a minute to do it. But
Thank you.
yeah, it's a Google form. Now, I don't know if that means, now, does that mean they have to have a Google account to sign it, or? Okay.
No,
No,
If they scan that QR code, it'll take them directly to the pledge also.
Let me pull that up again too. Thank you, Deborah.
So while Rubina is doing that, I want to thank everybody for being here today, taking valuable time out of your day and not watching the game and coming to hear Rubina instead. So we really, really appreciate that. Thank you so much, Rubina, for presenting a very wonderful and clear presentation on the cash bail system. And also thank you to Deborah and to Nell for being here today, despite the fact that you're supposed to be on vacation. So we're so glad that you were able to come. And thank you, everybody. And feel free to leave now if you want to, and you can stay if you want to, and make sure you sign the pledge. And if you're not able to do this, we'll try and send it to you on email anyways. Thank you, everyone.
Thank you so much,
great.
Izzy. Thank you so much, Mary Jo, for hosting this wonderful webinar. Thank you, Rubina. Awesome job. Just really the UU Church, UU Musian. I just can't say enough good things about you guys. We love you, seriously. Just we really, really love this coalition, this partnership that we're working on together. And just want to educate the public in terms of what's going on with the cash bail system. Wanted to say one thing with regard to that. On any given night in Michigan, up to 8,000 people can spend the night in jail, accused yet not convicted, because they do not have the money, the finances to pay for their freedom, to bond themselves out. And, this is a gross injustice to even what our Constitution say. We are presumed innocent until proven guilty. And so this is definitely harming those that don't have the means, criminalizing the poor. And so definitely please join our pledge, and please pass it on to others. This is going to be a hard fight, but guess what? We know Illinois did it, we know New York did it, and we are very optimistic that here in Michigan we can do it as well. Thank you.
Thank you, Nell. And thank you, everybody. Good night and be well. And we'll see you again another time.